this and he didn't specify the motion he was striking. I'm assuming he's striking his motion to withdraw?
I don't think so, Your Honor. I think maybe Mr. Yee was confused. I think Mr. Yee thought the motion that was on today was his motion to strike and his motion to withdraw, and thought he wasn't going to be present. It's clearly noted on the calendar as a motion to proceed pro se. I know Mr. Yee also has one pending, and I think maybe it got noted when he knew he wasn't going to be here. So he struck it thinking it was that, because it is on for next week, I believe. I think Mr. Yee's motion is on next week.
Okay, that makes sense. So, Mr. Nguyen, it does appear that your attorney moved to withdraw. He has struck that motion. He is not here. Mr. Shackleton, are filling it. Is that correct?
Yes, Your Honor. But as Ms. Stone said, this is the defendant's motion to proceed pro se. I don't think Mr. Yee would really participate in that proceeding.
No, but his presence would be important.
Okay, and that's why.
Thank you. All right. What do you want to tell me? And I guess I should set the stage and say that you made this request previously on July 23rd and was denied by the court.
I, Nico, over 18, am superior jurist living in professional biology. I am an authorized representative, grantor, executor, and administrator of Quinn Mike. Please address me by my true, correct name, Nico, the living man. Prosecutor Heather Stone required I, the living man, of liberty, life, property, and pursuit of happiness. I have here a certified copy of the 1889 State of Washington, which I signed, therefore I am a party of this contract. Article 1, Section 3, Personal Rights of 1889 State of Washington Constitution states, no person shall be deprived of life, liberty, or property without due process of law. Your Honor, there was and is no verifiable search warrant, nor was or is a verified warrant of arrest on file with any following agencies: Thurston County Sheriff's Office, Thurston Narcotics Task Force, and Thurston County Courthouse. I was unlawfully detained and was deprived of life, liberty, and property was taken without due process of law. Article 1, Section 6, Oath, Mode, and Administrative states the mode of administering an oath or affirmation shall be such as may be most consistent with and binding upon the conscience of the person to whom such oath or affirmation may be administered. Your Honor, there is also no probable cause supported by oath or affirmation, which makes the affidavit unsubstantial, and any search warrant granted should not have been issued for that reason.
Your Honor, is this a motion to proceed pro se?
Ms. Stone, please.
Article 1, Section 7, invasion of private affairs.
Sir, the judge.
I'm going to ask you to address the merits of your motion to represent yourself.
Okay. I, Mika Lumen, motion to proceed pro se, based on understanding that I, the man, cannot be presented by an attorney. I understand that the reason that the judge, including you, Your Honor, wear black robes is because all the dead legal fiction corporation entities that appear before you in court, and I mean that in the most respectful way possible. Your Honor, a dead person cannot speak and therefore must have legal representation, which I am not. Hence is the reason I must proceed pro se. I am not a defendant, but am a defendant of flesh and blood, and I am alive, therefore I can speak for myself. I am here on a special limited restricted appearance as a grantor, administrator, and executor for the defendant, Quinn Mike. I am hoping we can find a remedy soon as to save the public resources, my time, and the court's time. In granting my motion to proceed pro se, I feel that I can better assist in settling this matter. However, if the court feels more comfortable appointing me with a public defender free of charge, I will not object to have counsel on standby so as long as I am allowed to.
So the court did make a decision previously on June 23rd.
I think it was July, Your Honor.
July 23rd. A month's next day. The court had a long discussion with you at that time regarding whether or not you were the defendant. I think I'm hearing from you a little different language this time. But are you the defendant?
No, I'm not. I'm a living man. Standing right in front of you.
I know. I see.
Yeah.
You know, Miko, yeah. I'm sorry. I know this is important to you all. But I have certain constraints that the law imposes upon me. And that is, I can only permit you to represent yourself if I'm convinced that it is unequivocal, it is timely, and it's made with a general understanding of the consequences. And I have said before, earlier today and previously in other hearings, that I think you have the intellectual capacity to do this. But some of the fundamental things that you believe, and I'm not here to say they're not sincerely held, your beliefs that is, but is inconsistent with what I know to be the general consequences of this case. And so, again, having heard nothing different, I'm not going to change the decision that was made on July 23rd and deny your request. Now, as I say that, I know all of you feel strongly about wanting to say what you want to say. An attorney has ways of doing that. So the fact that you are represented by counsel as appointed by the court does not mean you will not have at the appropriate time the opportunity to speak on your own behalf. But at this point, I'm going to deny your request.